Hello, everyone. Welcome to the Fordham Business and Law Association's Fireside Chats. This week, we would like to welcome Lindsey Schmidt and Kady from Gibson Dunn's International Arbitration Practice. Lindsey is an associate in the New York office of Gibson Dunn, where she focuses on international arbitration in both international commercial and investor state arbitrations. Zach also focuses on investor state arbitrations, representing clients before the National Center for Settlement of Investment Disputes, the London Court of International Arbitration, and the International Center for Dispute Resolution, for example. I'd like to thank you both for joining us today.
Thanks for having us. And thanks for having us remotely from my bedroom.
Yeah, I'm sure that the COVID-19 has placed a bunch of restrictions and challenges on everyone, and I'm glad to see that everyone seems to be adopting fairly well to them.
Absolutely.
Yeah, we're certainly all getting more used to the video technology backgrounds, etc.
Sure. Well, with that, I guess we can go ahead and start going into some of the questions. So the first question we have is, for young lawyers interested in international arbitration, is it better to aim for a firm with a dedicated international arbitration practice group, or would it be preferable to sort of aim to get broad litigation experience at a firm with a global client base?
Sure, I'm happy to take this in the first instance. So I think, unfortunately, the answer that I would give is that it depends. I think that there are benefits and drawbacks to both approaches, and I can sort of walk through what I mean by that. I think if you absolutely know that you want to do international arbitration, that's helpful to know. I think in that case, you'll want to ensure either you go to a firm that has a dedicated international arbitration practice, for sure, that's one option. And then if you want to go to a firm that also is known for their litigation department, you'll also want to ensure that, of course, their arbitration practice is also robust. And so, that firm is also getting the kind of significant cases, the really large cases that you're looking for, both investor state, on the investor state side and commercial arbitration. You want to make sure that even if you're going to a place that's litigation heavy, that, ultimately, if you're going to end up in their arbitration department, it's a place that you want to be. Gibson Dunn's arbitration department falls into the latter category. We're very well known, of course, for our litigation department. We've won, I think, 4 years in a row, like Litigation Department of the Year. And the benefit of coming to a place like Gibson Dunn for arbitration is that you're pretty likely to be in the department and get significant experience in arbitration if you want to be. We staff our cases really leanly, so we usually only have a junior, mid-level, senior, and partner. So as an associate, you're doing everything. You're in client meetings, you're at the hearing, you are an absolutely an integral part of our team. I think sometimes when you go to some of the bigger shops that do mainly arbitration, everyone wants to do arbitration there, and it's actually quite difficult to get a spot. So it's something to consider when you're interviewing, when you are looking at a big shop versus a shop that has a smaller practice within the litigation practice, that there will be a spot for you. And so that it's important to sort of suss that out through the interview process when you're thinking about where to land.
Yeah, and I would add to that, when you go to a place like Gibson Dunn, for example, and a lot of other firms that have robust litigation practices as well, or maybe litigation practices that are larger than their arbitration practice, you should expect and be prepared to do some litigation too, especially when you first start, because that's what a lot of the firm's work is, and you'll get a lot of valuable experience doing litigation. And I think that's something we'll talk about throughout this discussion, some of the experience that's valuable to no matter what practice area you end up in. But if you start out as a junior associate and you're working in the international arbitration group, that's excellent. And if you're also working on, say, a pro bono matter or some larger securities litigation that you maybe didn't think is something you wanted to do, you are unknowingly gaining incredibly valuable experience about the business world, about how clients work, about your local jurisdiction and laws that will be applicable down the road. I think that it's important not to write off, especially as a junior associate.
Yeah, I think that's right, and I think when our junior associates come over to Gibson Dunn, we tell them for the first 2 to 3 years not to specialize in arbitration. We say, go to arbitration department, get experience in getting those research skills, those writing skills, learn how to be a very concise, crisp writer. That's what litigation teaches you to do, because you have page limits. We don't have page limits in arbitration. So those skills are transferable. And so we say that you should come in, even if you know you want to do arbitration, it's really important to do both litigation and arbitration. You're building your skill sets, and then you can come and specialize in the subject matter, as a third year, as a fourth year, and it makes you a better lawyer.
And I would say that's what Lindsey and I both did.
Yeah, that's exactly I both did.
Okay, thank you. That was very enlightening. And I guess a follow-up to that are, what kind of challenges are unique to this practice as opposed to traditional litigation, even that involving international parties?
So I think that there's a few different categories probably of unique challenges or just unique situations that you encounter in international arbitration. The first is kind of the obvious, time zone differences in language and culture between the attorneys, the clients, the tribunal, opposing counsel, and maybe the opposing party. You might have one party, from South America, the other parties in Europe, and counsels all in the United States, and the tribunal might be from all different places. They'll come from different cultural backgrounds and also different legal backgrounds, and you have to learn to bridge that. But you also have to adjust your advocacy for those differences too. You need to explain things in terms that are universally understood. You need to set the background sometimes when terms are not easily understood, or maybe you might expect them to be more easily understood if everybody were from New York, working in New York, litigating in New York. But you also need to adjust for the advocacy styles that people expect from different jurisdictions. For example, a UK tribunal or a UK arbitrator is going to expect a certain level of decorum that you will not find in New York State courts. I love New York State Court, but it is not. It is a unique place, and if you show up at an arbitration with kind of more academic-minded international lawyers in The Hague or Paris, and you have a more aggressive tone that might fit in perfectly in New York State court, it's going to come off wrong in arbitration. It's not going to help your client. It's not going to help you. So you need to be aware of those things and adjust for them.
So, I think that's exactly right. I think that, Zach's talking about the context of our, how we perform our advocacy and sort of those day-to-day challenges that we face. I think the other thing that's really different, just logistically, so our cases are huge. I don't think Zach or I have a single case that's less than, $750 million, and usually they're over $1 billion. And what goes with that is enormous pleadings. So typically in arbitration, you really only have, maybe 2 rounds of pleadings. Each set of pleadings is 300 pages, if not more. Along with that, you have one submission of your huge pleadings. That's your whole case. And with that comes your witness statements, your expert reports. And so you need to prepare and present your case sort of all in one go. At that point, you get a response to that, and then you submit your reply. And so I think that's a little bit different than what you might see in litigation, where you might have much shorter briefs along the way. We really have to think about our case from the very beginning. Think about it over the course of months and sometimes years. Even if we don't think a case is ready yet, we'll still, prepare it and work on the facts and work on the law and make sure we're ready to actually bring the case, because you have to sort of do it all in one go. Conversely with that, the body of law is much smaller in arbitration, and particularly in investor state. So I think there's only, there's less than 1,000 cases or something like that. There's maybe 1,000 cases out, investor state cases. And so whenever you're working on one of these pleadings, whenever you have a case, you really have an opportunity to become an expert in that. So if you have a jurisdictional brief you're writing, you become an expert on jurisdiction, because you know all of the, ratione temporis jurisdictional issues, because there's only 10 cases, right? And so you become the expert. And I think that is different than litigation. And that comes with these huge pleadings, these huge cases. So it's a challenge, but certainly there are benefits to it as well.
Lindsey mentioned you might assert a defense or respond to a defense on ratione temporis grounds, which it's not an exact analog, but let's compare it for this purposes to like a statute of limitations, where just the claim is brought, it's not the same, but the claim is brought at the wrong time or based on actions that occurred maybe before a statute was enacted is a better example. In litigation, you might file a motion to dismiss on that basis because they fail to state a claim because the actions took place before the law went into effect. But that's all you'll argue in that motion to dismiss. So you can have a very targeted argument and you kind of leave the facts aside. You'll address them later, assume they're true. But in arbitration, you need to think, okay, I'm making this ratione temporis argument and I need to make it cleanly and strongly, but I also need to fit it within the larger factual picture, the legal picture of my other arguments. Maybe you're saying it's irrelevant, you're arguing it in the alternative, but it's a little bit more challenging and requires more strategy and planning to fit an argument within the whole brief, the whole kit and caboodle. Whereas in litigation, you often, not always, but you often approach things more piecemeal.
Yeah, I think that, those are certainly some unique challenges to this practice area. And I guess like another question to that end is, given that just the nature of an arbitration in terms of submitting your entire case in one go and having to, or rather not having the opportunity to sort of make isolated arguments one at a time, what would you suggest that law students do to sort of gain familiarity with this practice, to sort of practice at least like the mental exercise of thinking about how to fit arguments that would otherwise be separated into sort of one cohesive thought process?
I think most of what you're going to learn about international arbitration, I think you're going to learn on the job. I think there are a number of building blocks that you can do in law school to try and prepare for a career in this space. But I think most of, unfortunately or fortunately, most of what you'll learn about the process is coming here. And so a lot of times people join our practice group and they've never taken a single international arbitration class. They've never taken an international law class. And it's not to say that you can't join the practice group if you don't have those building blocks, but there are certain things I think you can do to make yourself more ready. And in particular, if you know that you want to be in this group. I think fundamentally there are some classes that you can take at Fordham or at your law school that are critical. I think contracts is one of them. I know you have to take contracts, but most disputes come from some contract or another, whether it be a treaty in investor state or a contract itself in commercial arbitration. I think any writing research class you can take the advanced ones, because again, as a junior, so all the way up, I won't even say junior's associate, as an associate or a partner, so much of what you do is written. It's written submission. So when you're preparing for these 300-page plus pleadings, you want your writing to be crisp, to be clear. It's really the most fundamental way to communicate. And there are a lot of, everyone wants that oral advocacy piece. It takes years to get there, but your writing is from day one. So take any writing, any research class you can. The other class, and of course, any international arbitration class, just so you have, the fundamentals, sort of an overview at least of the fundamentals before walking in. The one class that I wish I took more of is corporations. I kind of avoided anything that had to do with corporations, math. I just said, I'll never need it. But I do now, unfortunately. And your clients are corporations oftentimes. So you want to know their business. You want to know how they're structured. You're going to have to give them advice on how to structure to be able to take advantage of treaties. And so, where I had a blind spot in law school for corporations, I wish I really dug into that a bit more to understand the structure of it, because those are the cases that come up time and time again. And so I think, at law school, of course, classes is number one. Those are the building blocks that you're going to need to know. And then I think the one other thing to think about is, you're thinking about these international disputes. I need to know international law, which you do. But even in these international settings, when you have clients from all over the world, when you're, you're dealing with counsel all over the world, people will still look to you as an expert in your jurisdiction. So, we have a lot of international cases, but New York law is at issue. And so people will still expect you to be the expert on New York law, even though you're doing international arbitration. And so I think that's also, fundamental for law students to make sure that they're digging into and continuing to learn and through CLEs and the rest. I guess, so that's what I would say is we put all of that together, that will really help prepare you for then your on-the-job training when you get to a firm.
Oh, no, I agree with all of that. And one other kind of course genre to consider is we had, when I was in law school, like a finance for lawyers class, and it was a short class, like a 1 or 2 credit course. Highly recommend that. Just learning how to read, people say this all the time, but learning how to read annual reports, balance sheets, understanding the concepts that your clients deal with every day, time value of money. It's such a basic concept. You'll hear it all the time. You won't really understand what it means unless you take a little course on it. It's not complicated, but a couple hours of somebody who actually knows what they're talking about, explaining it, will make a big difference. And it'll be a big benefit to you when you can discuss the concepts with your clients, or when you need to digest and summarize an expert report that's calculating damages or rebutting a damages calculation. If you know what those terms mean and how they work, and you will be much better off than if you did not know what they mean.
Yeah, I think that's exactly right. I mean, you kind of forget until you're working with your clients how important damages are to the case. You're like, oh, I won. This is great. We have a great legal argument. Okay, well, what are the damages? Ooh, actually, damages are not very good. That's the bottom line for your client, is how much, am I going to be able to recover from bringing this arbitration after spending, X amount in legal fees? What am I going to come out with at the end of the day? And that's what requires this financial accounting understanding. And that's what clients care about. And so you can't sort of kick that down the road. That's something that, you'll need to know pretty soon after joining on a case.
Yeah. And like the other way too, right? You might have a client that comes to you and you look at the legal question, you say, this is tricky. This is a close call, but let me see that. But you look at the other side's damages calculation, and you can see, because maybe you've taken a course in it, or you've learned from other cases, hopefully both, that there are fundamental problems, and they might not always be legal problems. They might be math problems, finance problems, business problems with their calculations. And your client's going to really appreciate when you tell them that, another law firm or their internal folks told them, there's a legal issue here. And you say, well, I agree, maybe we have to address this legal question. And it's tricky, but we can address the separate issue from a position of strength. It's good to identify those points.
Sure, I can definitely see how, as an attorney, kind of pulling yourself out from under the umbrella of the trope that lawyers are bad at math can certainly be.
Yeah, it's great. You got to get over that quickly.
Okay, and then I guess one last question is, could you describe your daily work as an associate working on international arbitration?
Sure, it's a bit of everything. As Lindsey said, our cases at Gibson Dunn are staffed pretty leanly and pretty consistently too, with a junior associate, a mid-level associate, a senior associate, and a partner, and some variations on that. But generally, the roles will work out where the junior associate is, you're not doing document review for days on end, like you might hear about or hear horror stories about in larger cases. And the reason is there just isn't the document review to do in arbitration. It's much more limited of a discovery process. So you're going through your client's documents, you're interviewing your client, you're understanding your case, your defense, and you're preparing documents to produce to the other side, reviewing the other side's documents. But that's a couple hundred documents, maybe 1,000 in some larger cases, which is not, maybe sounds like a big number. It is not compared to domestic litigation. So what that means is our junior associates get to be really integrated in all aspects of the case. They're in client meetings, they come to the hearing, they're involved in the hearing, they're critical to the hearing. And one of the reasons that they are so critical is because there's this universe of facts and documents, and they become the master of that without spending weeks or whatever it is in drudgery, just clicking through documents. You really understanding what each document means, how it relates to the case as a whole, and what's key. We don't need to worry about 1,000 documents that say the same thing. We focus in on the few most important ones, so does the other side, and then you have what I like about arbitration, you have a dispute about what matters. And the junior associate's role is to know that universe and then to give advice up the chain when somebody kind of drifts away from the documents that we have, or into some documents or to some facts that may not be so beneficial, and really be a resource for the rest of the team in building the factual part of the case.
Yeah, I mean, I think that's exactly right. I think the role changes obviously as you become more senior. I think as a junior associate, it's precisely what Zach's describing. Particularly at Gibson Dunn, you're mission critical for being on our team. The junior associates need to know every document, in particular at a hearing, right? That's who we rely on. We look down the row, and as soon as someone says something wrong, the junior associate's handing the document to us to let us know, how to counter something on cross-examination or something the other side said. So our junior associates, they are on the case. They do not do piecemeal research assignments. They know exactly what the case is all about, the strategy, and they're intimately involved. I think as you move up and you're a mid-level associate, you still are doing that very same thing. In some ways, I think a mid-level associate is one of the more difficult positions at the firm, because you're taking on a managerial role. You're managing junior associates. You are also involved in strategy in the day-to-day, and sometimes you're managing up, right? So mid-levels are managing up and they're managing down. And then I think as a senior associate in the case, you're the one that's really running the case, of course, with the oversight of the partners and discussing every issue with them. But as a senior, you're moving things forward. You now know how things work. You're coming up with strategy. You're managing a team in arbitration, international arbitration. You're managing teams all over the world. So we manage teams here in New York. You're managing teams in London, California, all the rest. So I think that becomes a very different role as well to take on. And I think, of course, it's firm specific, but the day-to-day of all of that, at Gibson Dunn, it's both investor state arbitration that you're doing day-to-day. We are on state side and claimant side. We do both types of work, and commercial arbitration as well. And I think what's unique to Gibson Dunn is that we don't only do arbitration. So, if you look at the life of an arbitration, you start out drafting the arbitration agreement. Even before that, you start out advising your clients on how to structure to take advantage of, an investment treaty. Then you help them draft, then you help your clients draft arbitration agreements. We then do the arbitration itself, and uniquely, we then enforce arbitrations. And that's where our department really overlaps with our litigation department. We work with our litigation department to enforce those giant, billion-dollar awards in court, because without that enforcement piece, you have a nice, pretty piece of paper that says you have $1.4 billion, but there's nowhere. But that's all it's worth. It's not worth the paper it's printed on. You hang it up, and that's that. You have to enforce in order to collect on that, and that's a whole practice in and of itself. And I think a lot of law firms do the arbitration piece, and then they hand over the enforcement to someone else. So that's something unique that our junior, mid-level, senior associates are doing on a daily basis, is working with our litigation team to do the litigation piece of the enforcement strategy.
Yeah. So let me add to that that's what it's like to be a junior, and also what good junior associates will do. You won't limit yourself to just the facts that are in front of you because we've collected a certain number of documents or interviewed this or that person at the client. You'll be spending a lot of your day working on a few cases. So you'll get really deep into the subject matter, but that subject matter, it's also on the news, maybe not, 6 o'clock CNN or whatever, but generally you're handling an important big dispute or a dispute that relates to an industry that is covered in some press. Follow them on Twitter. Read, put a Google alert for your client or for the issues that are relevant. A lot of days, maybe you won't read it, or there won't be anything there, or you'll just go past it. But you'll see when the big things happen, and then your case doesn't exist in the vacuum of what your client told you at the beginning of the case or the documents that either side produced. It can evolve right up to and through beyond the hearing. And if you, as a junior associate, who again is kind of really knowledgeable about the universe of facts in the case, if you're also knowledgeable about how they're evolving, how they are relevant in the industry, how they might evolve going forward, then you can talk. You can be a valuable member of your team, and your client will notice that you, again, know their business and know the news that they're seeing in their inboxes every morning. When you're in a meeting or call with them, you say, oh, right, and this company's doing that, or this country just changed this law that affects the industry this way. Maybe you need to prepare for that. Maybe the other side just moved a bunch of money somewhere through some bond issuance or something, and you want to write a letter to your tribunal to make sure that, seek some interim measures, asking them to stop dissipating their assets. If you were the one that was aware of those changes, that's incredibly valuable to everybody.
Very, very thoughtful. And I think it's relatively like pretty unique in the amount of detail and responsibility that your firm gives to junior associates. I think that's something that young associates would value in terms of just an overall learning experience. So yeah, with that, thank you both so much for your time to speak with me this morning. Good luck with your ongoing work, and we'd love to speak again soon.
Thank you. Thanks so much for having us.
Yeah, thanks, John. It's been fun.